These pictures were taken in March 2007 when the replica of the Zong slave ship traveled along the Thames, London, England. We will now discuss the Somerset case. The case of Somerset and Stuart of 1772, 98 English reports, 499. 9 years after Kofi's 1763 African Revolutionary War of Independence occurred in Berbice, Guyana, and 9 years before the 1781 Zong massacre of enslaved Africans in the Caribbean Sea, a leading human rights case in the history of African liberation from enslavement was heard in the Court of King's Bench here in London, England. The human rights movement began to develop in England in the latter part of the 18th century. A leading abolitionist campaigner, Granville Sharp, persisted with his campaign for the abolition of slavery and supported a number of enslaved Africans in court proceedings to assert their rights to freedom. Granville Sharp championed the cause of an enslaved African, James Somerset. Somerset had been brought here to London, England, from Virginia in America, and escaped. He was recaptured and held on a ship similar to the replica of the Zong. That ship was bound for the West Indies. Somerset issued proceedings for habeas corpus for his release, and it was argued that the air of England was too pure an air in which slavery could breathe. Lord Mansfield, the Lord Chief Justice of England, and 3 fellow judges held that the state of slavery could not be enforced in the English courts while the enslaved African was in England. The state of slavery was so odious that nothing could be suffered to support it but positive law. The case was not allowed or approved by the law of England, and Somerset was therefore ordered to be released. The decision was hailed as a landmark, but its consequences were grossly exaggerated. The main issue of the case was whether the enforcement of the laws of the American colonies would have allowed rights of property primacy over the liberty of the subject. Somerset was released, not because slavery was illegal under English law, but because there was not the legal machinery in place to enforce the laws of slavery which applied in the American colonies. Professor Folarin Shylon, in a detailed critique of the Somerset decision, described a large number of African people who had attended the court hearings, bowed to the judges after the judgment was delivered, and congratulated each other upon the recovery of the rights of human nature. Shylon, 1974, pages 108 to 110. He argued that Lord Mansfield had dithered and hesitated to pronounce judgment for a month because of personal weakness, economic or commercial reasons, the treatment of the enslaved Africans as property, and professional reasons. For example, his reluctance to overrule the opinion of the law officers York and Talbot. Lord Mansfield used the Latin phrase, fiat justitia, ruat caelum. Let justice be done, though the heavens may fall. Shylon further argued that Lord Mansfield worded his judgment carefully to ensure that it did not amount to a declaration of emancipation for all the enslaved Africans. As he was the father of English commercial law and was well aware that the owners of enslaved Africans would have lost at least £700,000 if the approximately 14,000 to 15,000 Africans in England at that time had received their freedom. Shylon, page 171. Shylon and Master Hewitt confirmed that despite the decision, examples of the impurity of English air for enslaved Africans could be given for decades after Lord Mansfield was supposed to have liberated them. They were still hunted and kidnapped in the streets of London, Liverpool, and Bristol. Shylon, pages 167 to 174. Hewitt, page 147. See the bibliography.